Good afternoon. This is Michael Buckner with the Buckner Law Firm. We will begin the program in approximately 1 minute. Welcome to Buckner's webinar, Lessons Learned from Recent NCAA Enforcement and Higher Ed Investigations. My name is Michael Buckner. I am an attorney and serve as president of Buckner and will serve as the presenter for today's program. Before we begin, let's review some housekeeping items. First, this program is being recorded. You can view the video of this webinar as well as other Buckner online workshops on our website, bucknersportslaw.com, or on our YouTube channel. You received via email yesterday several documents, including the PowerPoint presentation and the workout handout. You will receive later on today an email with access to our online evaluation form. And we highly encourage you to evaluate our program because that's how we improve our webinars and workshops. Email me at mbuckner@bucknersportslaw.com if you did not receive the materials. Third, your phone will be muted during today's webinar. Fourth, we will have a question and answer session during 3 portions of the webinar. The first session will occur approximately 20 minutes into the program. The second chance will occur at approximately 40 minutes into the webinar. And the final opportunity will be done at the end of the webinar. If you would like to ask a question, email it to me at mbuckner@bucknersportslaw.com. I will answer as many questions as time permits. Finally, if you cannot see the PowerPoint slides through the Meeting Burner webinar system, exit the system. And when you log back into Meeting Burner, be sure to download the screen sharing app indicated in the screen. Today's webinar will consist of a 2-part presentation format. The first part of our webinar will go into helpful strategies to prepare and conduct investigation interviews. And then secondly, we'll go into lessons learned from Buckner's recent NCAA enforcement and higher ed investigations, which will provide some strategies and best practices that you can take back to your campuses so that the violations, allegations, or misconduct that occurred in some of the cases that we've handled, you can prevent from occurring on your campus. Again, you'll have an opportunity to ask questions, and we will answer those questions during 3 portions of today's program. So if you have any questions, email them to me at mbuckner@bucknersportslaw.com. The objectives and benefits of today's program are as follows. During the first portion of the webinar, where we talk about helpful strategies to prepare and conduct investigation interviews, we will look at witness interviewing strategy and planning. And when you're conducting interviews, how to recognize truth from deception. Also, we're going to talk about conducting credibility assessments, and we're going to cover legal and ethical issues. And then, as I mentioned earlier, the second portion is about lessons learned from recent NCAA enforcement and higher ed cases that we have handled for our clients. And again, we're going to get some information to you so you can take it back to your campus. The sources of information that we use to develop this webinar are our experience conducting investigations and audits at NCAA member institutions, also our ongoing research into enhancing our own skills to conduct investigations. We've also shared our information and acquired information from other investigators and from the NCAA enforcement staff, and we're going to share that during today's program. And then also we've incorporated information that we've acquired from various books, including my book, Athletics Investigation Handbook, and other books dealing with forensic accounting, audits, and investigations, and just general investigative topics. Now let's begin with the first section, first part of our webinar, helpful strategies to prepare and conduct investigation interviews. On the screen, you should have 4 photos, one of Oprah Winfrey, Mike Wallace, and various other celebrities, Barbara Walters and Brian Gumbel. Each of these individuals, through their own programming, are seen or perceived to be really good interviewers. But each one has a different way of going about getting information from persons that they're interviewing. Oprah is allowed to, she normally interviews people in a really comfortable couch or on a show on a really nice set, and she's able to pull out emotional responses from her guests. When you see Mike Wallace on 60 Minutes, he's known as a tough, hard-hitting investigator, reporter, and getting people to crack under pressure. Brian Gumbel has a similar approach, but he's a little bit softer in his approach. But again, he's the one who really gets people to open up on hard-hitting issues. And Barbara Walters, again, she's similar to Oprah, but be able to get the celebrities to open up about their feelings and anecdotes and things that she believes her audience would actually find interesting. Each one of those have different ways of discerning where another person is telling the truth, looking at credibility, or at the end of the day, trying to get out information from those persons that they're interviewing. As you're developing your skills to conduct interviewing and internal investigations, you want to look at reporters, investigative reporters, detectives, persons that you feel comfortable with or you look up to that are currently conducting investigation interviews, to look at and observe the skill sets that they use in order to make people feel comfortable and to get information during an investigation interview. So as we go along during this first part, just think about the Oprahs and the Mike Wallaces and the Barbara Walters and the Brian Gumbels and the techniques that they use to hone their craft and to get the information during interviews. Let's go back to some basics of investigation interviewing 101. Remember, the purpose of an interview is to freeze a person's testimony so that you can use that later on in any type of proceeding. You also use interviews to clarify documents, data, and missing pieces that you're acquiring from reviewing documents or other testimony from other persons. And remember, an interview is one part of an investigation case. You're also looking at documents, doing analysis, doing forensic experiments, talking to experts, and performing other investigative activities. Remember, one of the best practices is to conduct your interviews after your initial document collection and analysis. That's so that you can have as much information as possible so that you know what questions to ask your interview subjects. And also, one of the key techniques is to create an environment for your interview subject to provide you with accurate and complete information. This is not a police interrogation. You're trying to facilitate your interview subject to open up their mind and to do basically an information dump to you, to pour out all the information out of their head and give that to you in as an accurate, concise manner as possible. Your job as the interviewer is to get accurate information. So therefore, create an environment in order to make that happen. Now, I get this question a lot. You know, everyone sees these procedural shows like a Law and Order, and they watch movies, courtroom movies, and they see, you know, police detectives interviewing a subject with a light in a dark room and pressuring people to talk. Well, those are interrogations. Interrogations are what law enforcement does. What we do in higher education and sports are interviews. Let me go through the difference. An interview is a process where you're asking a person a question who has knowledge of certain facts that you need. And you're trying to create an environment where they're going to give that to you. And an interrogation is where you already know or you think you know what occurred, and you're asking questions, but you're trying to solicit an admission or confession. Your purpose is not necessarily to gain the totality of the information. You pretty much already know, or you think you know, what direction the case is going. You're trying to get that person to either confess that they committed the crime or violation or misconduct, or they know the person that has information that can lead you to who committed the violation or the misconduct. Again, we try to do interviews in higher education and sports investigations. We're not law enforcement. The interviewing methods that you use are in-person interviews, which is where you're actually in the person's proximity, personal proximity, and so therefore you can do scheduled interviews where you scheduled that interview with the person, the date, time, and place, or cold call. That's when the person doesn't know that you're going to show up at their doorstep, whether it be their house or their business, and you use those type of interviews when you don't want the person to coordinate their testimony with somebody else. You can also do electronic interviewing methods, which means that you're interviewing the person using electronic methods, like over the telephone or doing a video conference. And there are advantages and disadvantages for each type of interview. In person, you're able to see the person's body language. You're able to talk with the person a little bit more before and after the interview. And electronic interview, you can't see the person's body language, but it's a lot easier to coordinate and schedule because you don't have to travel cross country. That's where the witness is. But again, you're going to lose some of the personal interaction that you would have from an in-person interview. Again, there are advantages and disadvantages, and you have to weigh those depending upon the budget of your client, the time constraints that you have in an investigation. Again, as I mentioned before, you want to facilitate the efficient transfer of information from the interview subject to you. So you want to create an environment where they feel comfortable, the interview subject feels comfortable in giving you information. So you want to conduct your interview, if you can, in a neutral location. That means a place where the interview subject feels comfortable in giving you information, and a location in which you are in control. That means you try not to interview the person in their office or in a place in which either they can be in control of or they would not feel comfortable in sharing information with you. So you will want to schedule an interview if you can. If you're interviewing an employee, you would not want to interview that employee in a conference room in their office suite because they may not feel comfortable sharing information with you if they know that their coworkers know that you're in a conference room talking to an investigator about an alleged event. So you want to probably schedule that in another building or another floor or somewhere else where you think that they would feel comfortable in sharing information with you. So let's go through the strategies in terms of interviews and the order of interviews. So there's 3 different types of main ways of organizing the order of an interview or the persons that you're going to interview. There's pyramid, reverse pyramid, and hybrid. A pyramid order is where, just like a pyramid from Egypt, you have the base of the pyramid, which is the widest point, and the point of the pyramid at the top. So with a pyramid, you're going to start at the base. You're going to interview the persons with the most knowledge, with the least amount of knowledge first. And you work your way all the way up to the point, which is the person that has the most information, which normally would be the target of the investigation. Now, even with a pyramid, you will want to interview first. The first person you want to interview, no matter what type of interview order you're going to use, is the person that made the allegation. If you're aware of the person that committed or actually submitted the allegation. Sometimes you may have an anonymous person, and so you can't interview an anonymous person, of course. But if you know the person, interview the person that made the allegation or complaint first, and then start off with the base of your pyramid. So the persons with the least amount of knowledge, and work your way up to the persons with the most knowledge. A reverse pyramid is what it means. You're reversing the pyramid. So the person, after the person that made the allegation, the second person that you're going to interview is the person that's the target of the investigation, which is with the person with the most knowledge. And then work your way up to the base. And the last group of people that you're going to interview are the people with the least amount of knowledge. You would use a reverse pyramid order if you believe that you need to freeze the target's testimony first, because say for instance you're going to have a high profile case, so you know it's going to get into the media, so you know that once the allegations and people start talking about it, that the target may change his or her testimony in order to fit what they see in the media or the reaction they're seeing in the media, or the media may spill some details about the investigation, which may damage the integrity of your case. So you want to freeze that testimony of the target first, and then work your way back to the people with the least amount. That's normally when you use a reverse pyramid scheme or order. Then a hybrid. And that's normally what happens because a investigation doesn't happen in a vacuum. There's going to be a lot of different issues that come up. So you're going to be faced with a situation where you may interview people out of order, or an order in which you would normally not do if you had a perfect world. And so that's basically going to strategize and interview people at the best time that you possibly can under the circumstances. Again, as I mentioned to you earlier about the pyramid, least amount of people knowledge first, and working your way up to the target, which is the point of the pyramid. Now I'm going to stop at this point, and we're going to have our first question and answer portion. If you have any questions for me, you can email them to mbuckner@bucknersportslaw.com. That's mbuckner@bucknersportslaw.com. Okay, I'm looking through my emails, and I do not have any emails at this point. But if you want me to answer questions during the second question and answer session, again, email them to mbuckner@bucknersportslaw.com. Let's go on with our program. Let's talk about assessing credibility and deception. And when you're conducting an interview, of course, if you're if you're doing an in-person interview, the person's sitting across from you from a table or in a chair or on a couch, and you're asking questions, and the interview subject is giving you their responses. And so as you're doing follow-up questions, as you're listening to the interview subject give you responses, one of your roles as an investigator is to discern whether or not they're actually telling you the truth. And if they're not, what are you going to do about it? Are you going to do follow-up questions? Are you going to suddenly confront the person with information that you know? But you have to really discern first if they're telling you the truth, or if they're uncomfortable with the direction of the interview. You're trying to control the interview, or you should be controlling the interview, because your role is, again, trying to get as much information from them as possible. So let's talk about how to assess credibility and deception. Remember, the importance of assessing credibility and deception is, again, to obtain accurate and detailed information of the allegations or issues under investigation. You need to figure out who's telling you the truth, who's lying to you, who's withholding information, who's providing inaccurate data or information, who's misleading you, who's exaggerating the facts. So remember, when we talk about deception and credibility, when people, normal people, I'm not talking about psychopaths, I'm talking about the regular person on the street that you're going to interview. When they try to deceive or lie, it produces stress. And through that stress, it is actually exhibited through verbal and nonverbal cues. And that is a guide to that person's behavior. So again, if they're lying, omitting information, or trying to misdirect you, those are forms of deception. So you need to look at when subjects are trying to manipulate your perceptions, because that's what happens. And sometimes subjects manipulate your perceptions of whether or not they're telling the truth or not, indirectly or innocently. So you need to look at factors that may influence their behavior towards you so that you can discern whether or not they're telling the truth or they're trying to deceive you. Because, and there are some listed on the screen, drugs, alcohol, ethnic, cultural, and economic backgrounds, lack of sleep, physical environment, could all be innocent basis for a interview subject that may influence or manipulate your perceptions of them. And these are all things that are not intentional. So you have to recognize that as well. There may be things that they're intentionally trying to manipulate you on, and things that you're not trying to. So you have to really discern that as well. And there's other behaviors of minors and persons with family romantic ties that may also influence you as well. Now, I have on the screen a beautiful woman on the screen, and that's my wife. I put the photo of my wife on the screen to illustrate a very important point. She is a human truth detector. She can tell when I am trying to deceive her, which I don't, because she has a psychology background, so she knows when I'm actually not telling the truth. And as husbands on this call, we all know our wives are human truth detectors. And I make this point that we all need to be if you're a husband, like your wife, which is a human truth detector when you're actually in an investigation interview. You need to be able to discern what the person is saying, whether or not that's truthful or not, or whether or not they're leaving out information. So be a human truth detector. So how do you do that? Well, here's some verbal hints of deception. These are things in which when an interview subject changes their verbal behavior or their responses, or you pick up different things and how they respond, those should be red flags as to whether or not they're trying to deceive you. That means changes in speech patterns. They repeat the question that you're asking all the time. They make comments regarding how the interview is proceeding. They seem to have selective memory of what they now seem like all of a sudden they don't remember stuff when before they were crystal clear with a great detail about everything that happened. They make excuses about situations or their responses. They swear on their testimony. They start making testimony about certain people's character, which is uncharacteristic from what they would normally do. When you ask them a question, they respond by asking you a question. Again, these verbal hints are not necessarily telling you that they definitely are deceiving you, but what they're telling you is that there are red flags that you need to follow up on or you need to be aware of, so that you can then be very, you can look at them and concentrate and see where you need to follow up or get some additional information to really discern where or not there is actual deception. Also, other verbal hints of deception are just being overly respectful to you, avoidance of any type of words that may emote emotion, very reluctant to terminate the interview. They just want to keep you there, and this feigning a unconcerned attitude. These and others are verbal hints of deception. Again, red flags that you need to go into further detail and review on. Now there's nonverbal hints of deception. Before you start an interview, you want to do a baseline check. You want to do a pre-interview discussion with them. Talk about the weather, sports, what's going on in the world. Stay away from politics, religion, of course, but just general topics which are innocent, which you can get a sense about who they are. And as you're talking to the person before the interview starts about innocent topics, you want to look at their baseline, their body language. How, when they're relaxed or somewhat relaxed, where do their eyes go? How do they use their hands? Where do their feet go? Do they tap their feet? Do they cross their legs? You want to look at everything so that when you start asking questions, if they deviate from that baseline, then that is another red flag that may indicate that they're deceiving you. So you're going to look at their full body motions during the interview. You're going to look at physical responses to your questions. If they put their hands over their mouth, if they look up with their eyes, if they begin to tap their hands or tap their feet, if they begin to cross their legs excessively, these are nonverbal hints that they may be deceiving you. Again, it doesn't necessarily mean that they are, but they're red flags that you need to consider and delve into further. Again, on this screen is another list of nonverbal hints of deception, a possible deception, crossing the arms, fake smiles. So you want to, again, look at this list as you're preparing for your interview for nonverbal hints of deception. Now, you use these hints once you have these red flags or hints. Well, how do you use them? Well, you use them because, again, as I mentioned, assessing deception is not a science, it's an art. And these are red flags or hints. It doesn't mean that they're actually deceiving you, but you need to follow up. So you want to use these hints because we want, we to believe in ourselves that people are going to tell us the truth. And we just perceive that. And so you need to pay attention because sometimes people aren't telling us the truth. People are deceiving you. So you want to be paying attention to that so that you can overcome our natural inclination to believe that people are telling us the truth. And we want to recognize this so that we can do the necessary follow-up. Now we're going to get to our second question and answer session. If anyone has any questions for me, you could email them to mbuckner@bucknersportslaw.com. at mbuckner@bucknersportslaw.com. Okay, I'm checking my emails, and there are no questions right now. If you have any questions, please don't hesitate to give those to me by email at mbuckner@bucknersportslaw.com, and we'll answer them in our next question and answer session. Let's proceed. Let's talk about witness interview strategy and planning. So when you're preparing for an interview, you're going to research the person that you're interviewing, what the allegation is, other possible targets involved in the case. You want to understand exactly what needs to be addressed in your interview. So if there are alleged crimes, misconduct, you need to research that. If there are any documents or photos you're going to rely upon, you need to review those. Any inconsistencies from prior interviews that that person may have had or other persons that have already been interviewed. Again, you want to study the methods to identify hints or red flags of deception. You want to make sure that you select the best location for the interview, confirm the date and time and location of the interview. You want to review the investigation file so that, again, you understand exactly what preceded this interview. Who said what information is relevant, what has been relied upon in the past. You want to prepare a question outline and a contingency plan. If something messes up, if something doesn't go right during the interview, how are you going to handle it? And so you just want to think of every single thing possible that could go wrong and could go right so that you can handle it in the best way possible. If you're going to be using documents or referring to documents, you want to make extra copies of those documents. And if you're going to be coordinating an interview with regulatory investigators or other legal counsel. You want to coordinate everything so that people are showing up at the right time, place, so that, again, you can conduct the interview on time and making sure that everyone that is supposed to be present is present. You want to select the best recording method for an interview. That means that you want to use either handwritten notes of the interview. You can use a digital recorder and make sure that you have extra batteries for your recorder, or you can use a court reporter or a videographer. Whatever method is the best way to for you and for the circumstances of the interview to actually create an accurate record of the interview. What you want to bring with you is something to write with and some paper or a notepad. You want to bring the copy of the pertinent laws or regulations that are at issue in the investigation. If you're going to use a interview notice form or a ethical conduct form or a confidentiality form, you want to have extra copies of those. And you want to bring something to identify you. You know, a lot of times you're going to be setting up those interviews over the phone or by email or by letter, and so the person sometimes will want to know that you are who you say you are, that you're representing a certain organization or law firm. So bring a badge, ID card, or some form of identification to the interview. During an interview, as an investigator, you want to be able to see the entire body of the subject if you can. Again, sometimes it's not possible due to logistics and the circumstances of the interview. But you want to be able to, this is not an interrogation, it's an interview, trying to get information from the interview subject. So you want to be able to see the person, their body language, so you can, again, get the hints or red flags of possible deception. You want to be respectful and professional during the interview because it can be documented. And later on, it can be used against you. And then also being professional and respectful gets the person comfortable to tell you what they have up in their head, which is the purpose of the interview. You want to observe body language for, again, deceit, possible deceit. And if you have an interview subject that may have issues understanding your question or may have a problem or difficulty in conveying an accurate response because they may not be a native speaker of your language, you want to give someone that can provide an accurate translation of that or to assist you in communicating. So if you have someone that is a native foreign speaker, you want to have a certified interpreter that can interpret the foreign language of the interview subject into English and then back into their foreign language. Let's look at some legal and ethical issues. When you're conducting an investigation of institutional or organizational misconduct, are there criminal rules or laws of state or federal nature that are implicated by the allegations? Therefore, you need to think about, do those need to be reported before you conduct the interview, before you conduct the investigation to the appropriate federal, state, regulatory, or law enforcement agencies? Does the allegation expose your school, your sports organization to civil liability? If so, you wouldn't want to have the general counsel or the outside counsel for the entity to be aware of the investigation and to be aware that the school or the organization may have liability. Has the allegation impacted the school in regards to any type of possible retaliation allegations? You will make sure that persons in an interview that you're interviewing understand that that you have a anti-retaliation policy, and if they feel they've been retaliated against, to provide information to the appropriate official. Also, if you have allegations that are implicating Title VII and Title IX claims, being able to deal with that with the appropriate organizational policy. If it's a Title IX claim for sexual assault, alleged sexual assault, then there needs to be a separate Title IX investigation. So again, these are some legal issues that you will want to address if you come across them with the organization's general counsel or other appropriate official. Also, ethical issues. And in your package that you that you received yesterday, attachments B and C pertain to this. You want to advise your employees or students that if you are an attorney and you're conducting the investigation, that who you represent. As attorneys, we have an ethical obligation. And for attorneys on this call, you have an ethical obligation to advise employees or persons that are affiliated with your organization who you actually represent, and that they have a right, if that's what your procedure provides, to have personal legal counsel during this proceeding. And if you're conducting an NCAA enforcement investigation, NCAA rules require that you provide an opportunity to have interview subjects to have legal counsel during an interview. So you want to make sure that they're aware of their ethical obligations. And what we do is we provide an actual interview notice to an interview witness so they know exactly what their obligations are, what their rights are. And those examples are in your packet, which you should have received yesterday. Now, sometimes interviews are going to be hostile. That means people are going to be angry at you, not give you information, have very hostile or body language towards you, get up and leave out of interviews. So sometimes the interviews are going to be hostile, and you have to prepare for that. And so you need to, if you think the interview is going to be hostile, what's the best location to have the interview? Should you have another investigator in there as well to do a buddy interview? Should you do a cold call interview so that the person doesn't have time to get angry? You show up on their doorstep at their house or at their office, and you can do the interview. Now, doing a cold call interview could also produce hostility. So again, you need to think about that as whether or not you're going to do a scheduled interview or cold call interview. You may want to do out of sequence questions. That if there are questions you think are going to, if you pose them to the interview subject, they're going to create a hostility, you may want to save those questions, possible hostile questions, toward the end of the interview. Now let's get to our next question and answer session. Again, if you have a question and answer question for me, I'll be happy to answer them at this stage. Again, if you have a question for me, you can send them to me at mbuckner@bucknersportslaw.com, mbuckner@bucknersportslaw.com. I have no email questions in the queue, so we will proceed with our presentation. In attachment A of your packet, you should receive a list of steps in an investigation interview. And we're going to go through those quickly. One, again, as I mentioned, you want to have a warm-up. You want to establish the rapport and baseline with the interview subject. You want to introduce your interview notice and your digital recorder. Step two is you start the interview, turn on the recorder, state the date, time, and location, introduce all the parties in the record, and you review the portions of your ethics code, your confidentiality statement, and the purpose of the interview. That's in attachment B of your packet. Step three, you gain the background information of the person, their home address, their contact information, social media, if it's publicly available, their business telephone address, if they're actual, not a student, but they're actual a person that has a established business, and if it's pertinent, their academic or athletics history and their employment history. Step four is this is the general phase of collecting the information, and you want to do a cognitive technique, which means that you're trying to facilitate the pouring out of all information out of their head. So you're going to do a very, very broad question. And that question should be designed so that it elicits as much talking from that person as possible. And then after they give the question, their answer to the broad question, then you do follow-up questions to that. So you're getting who, what, when, where, and how. And during this, you're observing their verbal and nonverbal behavior. You're looking at the reaction to your questions, the reaction as they're giving information. and you're writing down notes so that you know how to follow up or what type of follow-up questions to ask. Again, this cognitive broad question is called a stream of thought question because you're trying to get this subject to give you a stream of thought. And the longest I've had someone do a stream of thought response to a question was about 20-25 minutes. So you want to keep the interview subject talking. And you want to keep them talking as long as they can because they're just trying, you want to pour out all the information out of their head. Step 5 is clarification. This is when you're doing the follow-up questions. You're filling the gaps of what they said. You're expanding on what they said. You're describing people, places, and things that they told you in response to your cognitive question. Step 6, if you've done a good job with your cognitive question and your follow-up, you should have already pretty much hit all the questions that you wanted to ask. But sometimes that doesn't happen. So that's where the interview outline that you had prepared before the interview comes into place. So you want to make sure, go through your interview outline, make sure that you have answered all the questions or addressed all the issues that you needed to in this interview. Step 7, this is where you use outside information. This is where you use the documents and photos that you want to rely upon. If there's any things in the documents that you want to touch upon, this is the time that you bring those documents out. And this is when you find out if there are any other documents, if there's any other evidence out there. Step 8, this is for assessments and confessions. So you use this step only if you're properly trained and if it's within your investigative protocol. This is where you're going to, if you believe that you can, get the person to confess or to give you additional information that could establish your assessment of the person's credibility. So let me give you an example. Let's say, for example, you have a interview subject that you believe were actually conducting some type of misconduct. So you can exploit this situation and getting and trying to show sympathy and understanding for the interview subject's problems, so that you can get them to just tell you what they did. And I have up on the screen an example of a question saying, you know, I know the pressure you were under to win the World Championships. I don't know how you managed to do so well under the strain of meeting those expectations. You just did this to secure your contract extension, didn't you? So it's telling the person, hey, I understand where you're coming from. I understand the pressure that you're under. And trying to get them to agree to you to actually confess that they actually committed the alleged misconduct. Step 9 are credibility questions. These are questions that you can ask in this form, that you're thinking to yourself, and you can formulate questions in order to get the responses. But you're trying to get information to establish their credibility. So, you know, and there's some examples up on the screen that you can ask the interview subject. Again, on this screen, additional questions. And then step 10 is the wrap-up. And there's some questions on here that I always ask interview subjects at the end of the interview to wrap up the interview and to clarify certain things that occurred in the interview, and to do one last pass-through before I conclude the interview about the information that the interview subject did or did not say, including, did you understand and hear clearly all the questions posed to you during today's interview? Again, on this next slide for the warm-up, I asked, are there any questions we should have asked or issues we should have covered but did not? Again, sometimes the person say, well, you know what, I thought you were going to ask about A, B, and C. And so that gives you another line of questioning, another opening for that person to give you information. And then before you turn off the recorder, did I have your permission and consent to record this interview? Do I have your permission and consent to stop the recorder? Because at the beginning of the interview, you're going to ask a person permission to start the recorder. Under most states' laws, you have to ask the person's permission if you're in a two-party state to record them. So you're going to ask at the beginning, and then you ask at the end to stop the recorder. And then step 11 is a warm down. after I turn off the recorder, or you turn off the recorder, just chit-chat with the interview subject, and there may be some additional information that they wanted to tell you, but then after the interview is over and the recorder's off, they may tell you, and you have to go back on the record. That's happened to me a couple times. So again, this is another step that you can get some more information that might be helpful and relevant to your investigation. Okay, we're going to start off, before we get into our second and final part of our program, our next question and answer session. Again, if you have any questions for me, please email them to mbuckner@bucknersportslaw.com. That's mbuckner@bucknersportslaw.com. Okay, there's no questions in queue, so we will proceed with the second and final portion of our presentation, which are lessons learned from recent NCAA enforcement and higher education investigations. I have a true and false question up here, and that's NCAA legislation requires an institution to notify the enforcement staff within a reasonable time if it receives an alleged Level 1 or Level 2 violation. False. There is no rule specifically in either Bylaw 19 for Division 1 or Bylaw 32 for Divisions 2 and 3 that mandates an institution report alleged violations. Now, institutions are supposed to report violations, but not alleged violations. However, it is established protocol for a school to, if they receive a allegation that may turn into a possible Level 1 or 2 violation or major violation, to contact the enforcement staff and let them know that you received it and that you're going to proceed to conduct an internal investigation. Sometimes enforcement has already received the same allegation, or if they have not, they may ask whether or not they can also join in on the investigation. So let's look back at some lessons from our clients in the last few years dealing with higher education or NCAA enforcement investigations. We changed the facts and names and identifications of persons and parties and universities, but the most important thing is the lessons that we have learned from some of our cases. Verification of foreign academic transcripts. In this case, we had a prospect from an Eastern European country, attended the 11th grade in their country, then came to the U.S., enrolled in 12th grade. The U.S. high school received the prospect's foreign academic transcripts for admission purposes. They placed the foreign grades on their U.S. academic transcript. Our client recruited and admitted the prospect. They relied on the USA high school's transcript for admission purposes. But they received from the prospect's coach his Eastern European transcripts, which they sent directly to the NCAA Eligibility Center. The Eligibility Center identified the red flag in the foreign transcripts, and the NCAA later ruled that the university violated the rule, which is in Bylaw 10 and Bylaw, I believe, 14, requiring member institutions to validate academic records prior to submission to the Eligibility Center. Because under the NCAA rules, the university is liable and has an obligation to ensure that it's accurate and complete information that's submitted from the university to the Eligibility Center regarding a prospect's academic information. And our client did not conduct a thorough review or monitor or identify any red flags in the academic transcript. So the lessons learned from that, in terms of red flags, make sure that you have a process. Whoever is reviewing academic transcripts of foreign prospects, make sure that they're looking for inconsistent fonts and font sizes. Look like we're not the transcript. There's information that's cut and paste on the transcripts. There's details on the transcripts are inconsistent with what you know of a student's record. Teacher and courses appear in the same order, suggesting that they're just changing the grades of the subjects, cutting and pasting that information, and grade averages don't add up. Because again, they're cutting and pasting, but they're not changing any of the underlying academic results on the academic transcript. Also, birth dates on the transcript or other personal details are inconsistent with contemporaneous records that you may have acquired during the recruiting process. Unusual features. In our case, the academic transcript from the foreign country had the parent's email address under the school logo, which was very odd. Also, if the transcript has a principal or administrator signing the transcript, did that principal or administrator, were they there at the time when they allegedly signed it? Again, this case did not have that. The principal that signed it was no longer employed as a principal when allegedly he signed it. And are there details on the document inconsistent with any other aspect of the student's record? Concussions and injuries from improper practice drills. We had a case in which a student-athlete quit the team and signed a voluntary release, and later on the student-athlete and a parent alleged a concussion from improper practice drills, and that other student-athletes were injured in those same drills, and that the head coach actually did a lot of emotional and mental abuse on him and other student-athletes. Well, we did it in the investigation. We looked at all the practice tape. We looked at behind-the-scenes film within the locker room after games. We interviewed coaches, medical professionals, sports medicine staff, student-athletes, and we determined that there were improper practice drills going on. So, lessons learned. Athletic compliance and administrator with sports oversight for sports need to be trained to identify possible misconduct by the coaching staff, if there are any type of improper drills going on, or if the team is violating NCAA accountable athletic-related activity limits. So you want to educate and train compliance administrators on what to look for, coaches on what not to do, and student-athletes about if they believe that they're engaging in improper practice drills or they're being retaliated against or they have any type of grievance, when and how to report that. You want to, during your monitoring, you want to review or do a scan on a ongoing basis or a periodic basis to review practice videos, and you want to incorporate in your student-athlete exit interviews or annual discussions questions so you can get information so you can get a heads up on this issue. And you want to make sure your sports medicine staff, who is so important in these issues, has proper staffing according to industry norms and standards and protocols at practices and competitions, and understand they have a duty to report improper practice drills or areas or concerns that may lead to catastrophic injuries for student-athletes. Improper bookstore purchases. We had a case where student-athletes received an $800 book award with their athletic scholarship. The bookstore vendor told students with academic scholarships they could receive up to $30 in supplies. And so the student-athletes use that book award to purchase non-course required supplies, so electronic devices or personal items that they use not in class but for their own personal use. Of course, right now that's against the NCAA legislation to do so. And so best practices are have written policy procedures for bookstore-related purchases by student-athletes, using technology available to track and to block impermissible purchases by student-athletes. Remember, whatever system that you use, test it, and to make sure that there is some type of monitoring of purchases in a post-purchase process. You want to make sure that you're educating everyone involved in the process on NCAA legislation. That starts from the bookstore all the way through to student accounts and academics. Anyone who may have touched or had an input or involvement in the bookstore process should be educated on NCAA legislation. And then you want to have in-store monitoring. That means someone in the bookstore when the student-athletes are purchasing books, you can arrange that by team or on certain days so that they are also there checking to make sure that student-athletes are only purchasing permitted items with their athletics awards or scholarships. And then post-purchase monitoring. After the purchases have been made, that someone from the school, whether it be someone in academics, compliance, or other area, are looking over the receipts or other reports of the bookstore purchases. Then head coach control. Again, there's NCAA has strict rules on the fact that head coaches are obligated to promote an atmosphere of compliance and then to monitor their staff and student athletes in compliance with NCAA legislation. So we had a situation where in international recruiting, a head coach was going overseas to recruit, did some impermissible, provide impermissible benefits while recruiting, and also did it during impermissible recruiting periods. And then also brought over a student athlete, which he was not supposed to do because the student athlete was not eligible. The ineligible prospect showed up in the U.S., and the head coach put that prospect up in a house from a booster, which again created additional violations. So for important lessons, remember that to educate head coaches about their head coach responsibilities, as well as general aspects of NCAA legislation, making sure that they are having meetings on an ongoing basis, or at least annually, with the president or chancellor, on an ongoing basis with the athletic director, with the senior compliance administrator or someone from the compliance staff, and their sport oversight administrator, to making sure that they understand their obligation to monitor their program and to promote an atmosphere of compliance. And then countable athletic-related activity violations. We have two examples where a men's sports team did pre-5 a.m. pre-practice activities. Under NCAA rules, of course, as everyone on the call knows, you cannot conduct athletic activities under NCAA rules after 12 midnight, and before 5 a.m. Well, this team was doing their pre-practice activities, required stretching and light running prior to the 5 a.m. practice. And these activities were monitored or requested by the head coach, and they also exceeded their 420-hour rule limits. NCAA legislation limits practices per day to 4 hours per day and 20 hours per week. And this team actually exceeded that, and the coach did not provide the team with at least 1 day off per week. And for a women's team, again, they were doing pre and post practice activities that were deemed to be mandatory, but they were not recording those pre and post practice activities on their practice logs. So therefore, once we went back and totaled them up, they exceeded 4 hours per day, 20 hours per week some days, and did not provide the young ladies with the necessary day off. Now, this team also had an APR practice limitation, which they violated. The lessons learned are, again, to have a compliance manual with specific procedures relating to countable athletic-related activities, to educate the coaches, student-athletes, and support staff about NCAA rules dealing with practices and competitions, and to have a system, whether using technology or other, specifically software, compliance software, to document the practices and have the student-athletes sign off on those logs. And to have on-the-field monitoring by compliance and administrators or sport oversight, and to document that on-the-field monitoring. And then again, have open communication with student managers, sports medicine, and in student-athlete exit interviews and annual discussions, getting information from student-athletes so you can get ahead on the issue of countable athletic-related activity violations. Before we proceed to our last question and answer session, I want to remind you Buckner conducts at least one complimentary webinar each month for you and your staff. The list of currently scheduled programs is listed on the slides and is available on our webinar page at bucknersportslaw.com. You can view the video of this webinar and other Buckner online workshops on our website, bucknersportslaw.com, or on our YouTube platform. Finally, for a reasonable fee, you can request a Buckner professional to conduct a topic of your choice on your campus through the firm's Campus Speaker Series. For more information on this series, please contact us at Country Code 1, area code 954-941-1844, or send us an email at info@bucknersportslaw.com. Now we're going to proceed to our third and final question and answer session. If you have a question for me, please email them to mbuckner@bucknersportslaw.com. That's mbuckner@bucknersportslaw.com. There are no questions in the queue, but if you have any questions for me, you can email them to me after the program, and I will respond to you within 48 hours. Before we conclude this session, I would like to invite you to share your comments and input on today's program by completing the evaluation, which will be provided to you through a link in an email that you will receive at approximately 1:30. Thank you for your participation during today's webinar. We look forward to your participation during our next events, which are listed on our website, bucknersportslaw.com. So be on the lookout for the announcement. Thanks again, and this concludes our session.